Very good evening, students. Good evening, Anu, and everyone, those of you who have just joined. So, let's begin with this class. So, first of all, I welcome each one of you to my class on the topic Trial from the Code of Criminal Procedure 1973. So, let's begin with this class. With my brief introduction, my name is Sandeep Khatri, and these are my areas of specialization: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, here is the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can ask questions in relation to your judicial preparation. And at last, I have mentioned my code, that is Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you are not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. So we are about to start the MCQs. So I hope you all are ready. So let's begin with the test. The very first question: trial before a court of session under chapter. So answer the question: A, B, C, or D. One more thing, students, make sure you write the question number in a numeric form first and then the answer, whatever you feel like. Yes, there are four types of trial when it comes to CrPC. The very first one is trial before a court of session, then there is a warrant case trial, then there is a summon case trial, and the last one is your summary trial. So trial before a court of session is in chapter number 18, students. So D is the correct answer. Moving towards the next one. Under section 225, in every trial before a court of session, the prosecution shall be conducted by. Who is going to represent the prosecution? Option number A, assistant public prosecutor. Option number B, public prosecutor. Option number C, directorate of prosecution. And the last D option is advocate. First one to answer correctly, Tejaswani, correct answer. So the answer is public prosecutor. Okay, so basically prosecution, who basically represents the state, the answer is, students, the public prosecutor. Under section 229, if the accused pleads guilty, the judge shall record the plea and dash convict him thereon. Fill in the blanks. May. Tejaswani, correct answer. See, students, once the accused pleads guilty, then the judge shall, this is mandatory that he shall record the plea, but this is completely the discretion of the court whether the judge want to convict him thereon or wants him for the trial. So the correct answer is the discretion. So A is the correct answer. Next one. If after taking the evidence for the prosecution, examining the accused, and hearing the prosecution and the defense on the point, the judge shall consider that there is no evidence that the accused committed the offense, the judge shall record an order of dash under section 232. Choose the most appropriate option: discharge, acquittal, conviction, or last option D is your reference. Tejaswini, you have answered discharge. That is option number A. Okay. Tejaswini, please do correct yourself. Okay. The correct answer here is acquittal. Now, let me give you the reasons why the answer is acquittal. See, hearing the prosecution and the defense, and the judge consider that there is no evidence the accused has committed the offense, which means both the sides have presented their case and still there is no evidence that the accused has committed the offense, and then the judge shall record the acquittal. So B is the correct answer. Okay, it's okay, you don't need to be sorry. Next one, warrant case defined under section. One of the most repeated question, one of the most important section number. So this term warrant case has been defined under section. So section 2 is basically a definition clause. Various terms has been defined. Tejaswini, W. Anurag, 2W. Okay, Tejaswini has changed her answer. Anurag, please do correct yourself. When it comes to this term warrant case, this term has been defined under section 2 clause X. Okay, 2X. Okay, 2W is basically your summons case. Okay, so D is the correct answer. Warrant case means a case relating to an offense punishable with imprisonment of exceeding dash under section 2 clause X. Yes, correct. Tejaswini, 2W is summon case. Okay, top 3 students to answer correctly. Tejaswini, Anurag, followed by Dinesh. Yes, A is the correct answer, students. That is basically 2 years we are talking about. So exceeding 2 years is going to be treated as warrant case. Yes, death penalty, life imprisonment, and more than 2 years. Correct one. Summon case defined under section. We have just discussed in the previous one. So this term summon case has been defined. Anurag, correct answer, followed by Tejaswini. That is 2W. Now let me tell you this important, students, why these two terms are very important. What is summon case? What is warrant case? I just told you in the introduction that today our topic is of trial, and when it comes to trial, we do have 4 topics. The first one, chapter number 18, that is trial before court of session. Then followed by chapter number 19, that is trial by warrant case. Then followed by chapter number 20, trial by summon case, and the last one is your summary trial. Okay, chapter number 21. Choose the most appropriate answer. Which of the following is a summon case? Tejaswani and Anurag, please do correct yourself. When you say which of the following is a summon case, if you are saying with imprisonment of 2 years, why not imprisonment of 1 year or imprisonment of 3 months? So it all comes under the 2 years. So that is why the correct answer is going to be D, all of the above. Okay. So please do read the question carefully. Okay. Dinesh Bharti, first one to answer correctly. Next. Which of the following is true under section 259? Power of court to convert summon case into warrant cases. Power of court to convert warrant cases into summon cases. C, both A and B. D, none of the above. Okay, Aru, I'll take the answer. Actually, I cannot take, but I can highlight. I hope that will work for you. So I'll highlight the correct answer. Okay. Tejaswani, Anurag, both has answered correctly. Yes, students, when it comes to section 259, the correct answer is power of court to convert summon cases into warrant cases. So this is the correct answer. Okay. I hope, Aru, this highlight will work. Okay, you are welcome. Next one. Trial of summon cases by magistrate under chapter. So summon cases trial are under chapter number. You must know the sections as well, students. So when it comes to summon cases, from which particular section it goes to till what? Anurag, Tejaswani, correct answer, students. So when it comes to trial of summon cases, the correct answer is your B, chapter number 20. Okay. If application of section 257 is allowed, then the accused will be. What are going to be the consequences of application of section 257? If that is allowed, so first you need to know what is section 257, and then they are basically asking you the consequences of 257. So 257 is basically withdrawal of complaint, which you can do only with the permission of the court. And if that is something which is allowed, then what is going to be the status of that particular case? Okay. Good, Tejaswani. Dinesh Bharti, first one to answer A, followed by Tejaswani and Anurag. Yes, students, once there is withdrawal of complaint, then the person will be acquitted under section 257. So A is the correct answer. Which of the following trial is differentiated on the basis of police report and other cases? Option number A, trial before court of session. Option number B, trial of summons cases. Option number C, trial of warrant cases. Option number D, all of the above. Okay. Tejaswani, Anurag, correct answer. Okay, so let's first come to the answer of this question. So the question is on the basis of police report and other cases. So the correct answer here is C, that is trial of warrant cases. So C is the correct answer. Now who can tell me in the comments that we know about the police report? Okay, then we know about the police report, but what about these other cases? Can anyone give me some example of other cases here? What we are talking about? Other cases? Yes, please, in the comments. Okay, Tejaswani, correct answer. When it comes to these other cases, we are basically referring to the complaint proceedings, or we are basically referring to where the magistrate has taken the cognizance suo moto, or that has been based on any particular information. Okay, so yes, and the police report you already know, that is from FIR and so on. Next one. Who has no power to try summarily under section 260. First one to answer correctly, Tejaswini. Kitty Prakash, please do correct your answer. See, the question was who has no power, who has no power under section 260 to try summarily. But when it comes to CJM, and you will read section 260, that is the first one to in the list. Similarly, Metropolitan Magistrate also has power to try summarily under section 260. But when it comes to Judicial Magistrate first class, he needs special empowerment from the High Court, and only then he can try summarily. Okay, so the correct answer is here C. I just told you the answer of this question. Magistrate of the first class has power to try summarily under section 260 only if empowered by. Kitty and Manisha, please do correct yourself. You know, students, you usually get confused. Everyone listen this carefully. When it comes to section number 190, okay, when it comes to the power to take cognizance, it is usually taken by judicial magistrate first class. Fine. But as far as section 190 clause 2 is concerned, if that particular if judicial magistrate second class is empowered by chief judicial magistrate, that is CJM, then judicial magistrate second class may also take the cognizance. This is section 190. But when we are talking about section 260, then we are talking about that who may empower judicial magistrate first class to power summarily. Then the answer is not chief judicial magistrate, the answer is High Court. I hope now it's clear. And still, if you have any doubts or confusion, feel free to ask your questions in the comments. Okay. चलिए जी. Next one. The procedure for summary trial under section 262. See, the procedure we are talking about when you will go through with chapter number 18, 19, and 20, there is a specific procedure that has been given. Okay. Now, when it comes to summary trial, there is no procedure that has been given. So, whose procedure will be followed here? Summon case, warrant case, or session court trial case? Or last option is D, none of the above as per to your section number 262. Okay, I need to make one important announcement as well, students. I hope you all are aware with that. As of now, the bomb has finally dropped by UP Public Service Commission. Your date for the examination is out. That is going to be 12th of Feb 2023 for your PT examination. Okay. Manisha and Tejaswani. Aru, the answer of your question is not. Aru, answer to your question. This is not under CRPC, okay? There is no such provision as far as CRPC is concerned, okay? Okay, now, under section 261, who may confer magistrate of second class power to try summarily? Who can do that? And students, here the correct answer is the High Court. Similarly, uh, whether it is about section 260 to empower judicial magistrate first class to empower to judicial magistrate second class under 261, the answer will remain the same, that is the High Court. Okay, next. The High Court may confer on judicial magistrate second class with powers to try summarily any offence which is punishable under which cases. Tejashwani and Shruti, A is the correct answer, students. So, where only with fine or with imprisonment for a term not exceeding 6 months. That in these cases only, a judicial magistrate second class may be empowered to try summarily by the High Court. No sentence of imprisonment for a term exceeding dash shall be passed in a case of any conviction under summary trials. Vandana, Tejaswani, and Santani. C is the correct answer. Okay, wait, sorry. Sorry. Tejaswani only has answered this correctly, and that is 3 months. So please do correct your answer, Vandana and Santani. Okay. So the maximum imprisonment that can be awarded under summary trial is 3 months and not 6 months. Okay. So 3 months is the correct answer. Provisions of summary trial given under sections starting from which till what section? Top three students to answer correctly: Manisha, Vandana, and Tejaswani. Yes, C is the correct answer. That is starting from section 260 till 265. The term summary trials has been defined under section. Manisha and Shruti, please do correct your answers. Tejaswani and Santani, correct answer. So students, when it comes to section number 260, this is basically the who has the power to try summarily. Under section 261, it is about judicial magistrate second class and how he can, do summary trials. Section 2W is summon cases. So the correct answer here is not defined. So now anything which you are not clear with, you may ask. Yes, please. So students, this is the link of my profile, my Telegram channel, and this is my code Khatri10. So this was about me. So let's crack PCS J with Unacademy. These are some batches which has been recently started from December 20th. Rapid revision for UP and Chhattisgarh Judiciary. This is the Prarambh batch starting from December 27. Sankalp UP PCS J prelims batch started from December 17th. This is the revamped test series offering for this December from Unacademy. This is the Unacademy subscription for the Plus and the Iconic courses. This is the Articulate coming soon monthly current affair magazine from Unacademy. These are the YouTube channels from Unacademy, and these are the Telegram channels of Unacademy. Yes, Aru, the class will take on a daily basis at 7 p.m. Shruti, the timings are 7 p.m. Yes, I do take classes regularly. Tejaswani. Anything else? Any question in your mind, you may ask. So tomorrow you can expect the concept of plea bargaining and so on. Okay? Chaliye, you're welcome. On that note, let's conclude this class here. See you in my next class. Till then, yes, it's time to say peace.